Honourable David Parker.
Mr Chairman, the irony of this is that the Minister has just listed a large number of protections that surround the use of examination order powers that have been conferred to the police. First point, Mr Bridges, those powers don't currently exist for production orders to the police, and this is a very, very significant new power being conferred to the police, because it is a very important exception to the right to silence. At the moment, in New Zealand, we have a right to silence. We do not have to cooperate with the police and answer their questions. There are lots of reasons why that historically has been the case. There are lots of societal reasons why it is that you don't want to compel people to give evidence against their friends. They often choose to do so, but you don't force them to, because you create tensions in society that, amongst other things, bring the police into conflict with the population, and therefore the population are less likely to cooperate with the police in the future, and there's an overriding objective that we want to maintain cooperation with the police. That's but one reason. You don't want to be sort of pushing members of the family against another member of the family, so we don't compel people to talk to the police. We encourage them to do so, but we don't compel them to. Another reason is, if you compel people to, it doesn't mean to say that you can compel them to tell the truth. And you're more likely to get fictitious evidence if people are forced to talk to the police or to the other authorities than if they do so voluntarily. So those are the reasons why we do not normally compel people to talk to the authorities, or some of them. I don't have time to go into all of them. But, Mr Chairman, there are occasions where it is important that the police release people from obligations of confidence that they owe to their principal. For example, an accountant who was involved quite innocently in a money laundering operation for a drug ring cannot disclose that information voluntarily to the police, and some of it might not be recorded in a way that can be obtained through a search warrant getting documents. And so you release the accountant or the lawyer from their obligation of confidence, and they will be willing to talk, but they can't without being released from that obligation of confidence. And that's why on occasions it is appropriate to have examination orders. So this can be justified in some circumstances, but you have to be very careful that you're not opening this gate too wide, as we found with the serious fraud office. So what are we doing here? Well, it came to Select Committee already with more protections than exist in respect of the serious fraud office. But the Select Committee added even more, and the Minister's SOP adds more protections still, which is a good thing in respect of the police. What did we add? Well, we said already, we were saying it had to be through a warrant. It had to be through a warrant. It's now made clear that the warrant can only be issued by a judge, not a registrar. Serious Fraud Office, they don't even have to get a warrant. It's Internal Administrative Act. What a nonsense, eh? What a nonsense. Second protection. It came to the Select Committee saying that the offence which was being investigated had to be imprisonable. We upped that in the business case to something that had a period of imprisonment of 5 years or more. So it's a lot more serious than it when it came to Select Committee. No equivalent provision in the Serious Fraud Office legislation. Next thing the Select Committee did is, in respect of non-business situation, the threshold's even higher. It has to be 7 years or more imprisonment as the penalty under the offence before you can get an examination order. Then, as the Minister said, if this is ever used against the media, and it shouldn't be, generally, it shouldn't be, but if it ever was, you have to close off the potential that it could be. You can't have an absolute prohibition, because actually it is possible that members of the press can be corrupt and involved in criminal conduct themselves. Very rare, but it can happen. So you've got to leave that possibility open, but you've got to put protections around it, Mr Chairman, so that it's not abused. So how do you do that? Well, you actually say that any records, anything that comes of it can be objected to through this process that the Minister referred to. They can claim that they shouldn't be forced to give evidence relying upon privilege. Now we're talking, Mr Chairman.
Honourable David Parker.
Now, we've heard reference from the Minister that there are various sorts of privilege that could be claimed. Legal professional privilege, I think, was one of them. Was medical privilege mentioned? I don't know that it was. Legal professional privilege and also the interest of media freedom. How do you assess that? Well, you actually put it in front of a judge to make that assessment rather than letting the police make the assessment themselves. How's that different from the Serious Fraud Office? The Serious Fraud Office don't have to do that. They don't have to do that. So at the moment, we've got the Serious Fraud Office being able to go into the media, force them to answer questions, put the journalist and the news media company at risk of criminal prosecution because their refusal to answer questions is, unless they're claiming the privilege against self-incrimination, their protection of a source is illegal. It's illegal in terms of the Serious Fraud Office legislation, and that exposes them to criminal penalties. How can that be right? It's not right for the police. The Select Committee, the government and the Minister already have agreed that we need protections and more protections, but they won't move on this protection for the media. Why won't they? Because there's no principle behind this. Ask yourself, why won't they? And the answer is that they're trying to position the opposition, and we heard the Minister and the Chair say this in her second to last contribution. They say, because we oppose this bill, we're soft on crime. Yes. That's what they're trying to do here. That's what they've been trying to do for 2 years. They've been trying to say that because we are taking a principled position for the protection of the media through making sure that the same protections that are in there in respect of examination orders in respect of the police for the media protection also apply in respect of Serious Fraud Office actions. They say, because we're taking that principled position, we're soft on crime. No, Minister, what we're doing is we are protecting civil liberties. One of the most important civil liberties is maintained through a free media who are unconstrained in their ability to investigate things that have gone wrong, to investigate corruption, to make sure that corruption doesn't happen again. That's what happens if you investigate, shed light on it, people get prosecuted, governments fall, and there's a disincentive to corruption. That's how you keep a clean democracy. If you can't investigate corruption properly because the media sources won't speak up because that source could be disclosed under an examination order by the media or forced to be disclosed by the Serious Fraud Office, you undermine democracy. And that's precious to me. That's really precious to me. And that's why I'm quite happy to say that the existing law is wrong and that the Law Commission were right to recommend to the prior government that this power be constrained. In fact, they originally recommended that it be taken away completely from the Serious Fraud Office. After they considered again and there were submissions, they actually got to the point where they and the Department, I shouldn't forget the Department of Justice, they also, or the Ministry of Justice, they also agreed that there should be a constrained version of this power eventually, but this government won't do it. This government says that they're not going to because they, for political advantage, are trying to position the Labor Party opposition who are trying to protect media freedoms and our democratic institutions. They're trying to say that makes us soft on crime. Who's soft on crime, Minister, is your government, who does not see that this sort of law exposes our democratic institutions to the risk of corruption, to the risk of negligent behaviour not being exposed, to the risk of losses such as we've had in South Canterbury Finance, where there are hundreds of millions of dollars of extra money lost because of government, according to the Auditor General, because of government inaction in terms of letting the loan book grow and that sort of thing. That sort of thing cannot be as well investigated by the media if their sources are at risk. And that's why this is so important. So the amendment that is in my name extends the same protections that are there for the media in respect of the police, now that they're getting this additional power, and says that those same controls should be on the Serious Fraud Office, and I think it's patently clear they should be. I think most people in the Media Freedom Committee thinks it is, all the newspapers think it is, the radio think it is, the TV think it is, and that's why this game that the government's playing, trying to say that our actions on this are soft on crime, is actually not working for them. Instead, they look shady, as they are. This lines up. Mr Bridges, this is Mr Bridges' contribution is to say that this does show us to be soft on crime. This is the man who just told this House there was no extension to police powers in this legislation, which was completely wrong.
Dr. Jackie Blue.
Thank you, Mr Chair. I'm very pleased to speak to Part 2 of the Search and Surveillance Bill.